what type of issues, like underground, like even like environmental issues?
That's a site plan put in the traffic impact study for the purpose of doing the traffic analysis. There would be a whole package called the for the site plan approval itself, independent of the traffic study. Yeah, it's included there for the purpose of illustrating the traffic study, but it would be a separate. It would be,
Yeah, it's a process for mobile for any location. So I guess that's why he came in.
it might be the same one, but
Just make sure.
but it would be
I'm
under
sure
that. There would be a whole
the
set.
document.
Yeah, there would be.
Document.
There would be a packet.
Our organization
Here's the site plan. Here's the survey. Here's the elevations. Here's the that kind of thing.
I guess that's the influential part too, like, okay, can we take over your own one? So environmental issues, political issues, and everything.
We go to the city and get
More
that,
about
right?
like what they did to actually.
Yes.
Self-approve, which are with the home.
Go to the city and
Yes.
like pull it under the rug.
Yeah, and sometimes it can be expensive, and so you can ask, you should be able to ask to see it without paying any money, and then you can ask, you can limit, make sure that you're only asking them to copy what you really need. And
Is it a long term?
sometimes it's 24 by 36 plans, and it'll be, you know, and it can be expensive to copy, and you may not want or need the whole thing. And some cities are just, this is Hallandale, not Dana Beach,
What
right?
everything
No, that's
going on,
Dana
moving,
Beach.
and then.
This is Dana Beach. Dana Beach,
Like prior to.
they sent everything out to be scanned, and they make you go pay.
The whole thing.
It can be difficult to get public records from Dana Beach because they use a third party to provide them now. So again, be really nice, appeal to the fact that you probably had to do this when you were getting your planning degree, and you know, see what you can get them to give you. But I just had a bad experience with Dana Beach. They wanted to charge hundreds of dollars for research and all sorts of things. Yep. Yep, hopefully it's good quality that you can print or copy into your PowerPoint. Good. Good. I did. Yep, good, good.
Did you see?
I'm the king of research.
See, you're getting there. And just so that you guys know how old I am, when I started doing this work, we started with REE books, which, do you know what a REE book is? It's like a gigantic book of aerials,
I guess so.
and you had to find the subdivision and find the lot and look at the zoning, and it only got updated once a year. That was just a nightmare. And none of these codes were online. We used to have a library full of all the. I had to walk uphill to school both ways in the snow.
Okay.
So we'll send it to you.
Thank you.
You guys need a little, let me go through a little bit more material, and I will give you more time to work on your project after. And we're going to have one more class that will be covered in the midterm. So next week's class will be covered in the midterm. 2, okay? We're going to have 4 classes covered in the midterm.
I'm sorry, say that again, the next class is gonna be within the midterm
Yes.
as well? Okay.
Yes. All right.
Let's do it.
Review. We've done some review already, so I'll buzz through this. Comprehensive planning in Florida is based in Chapter 163 of Florida statutes. There are required elements listed here: future land use, capital improvements, transportation, utilities, conservation, recreation and open space, housing, coastal management, intergovernmental coordination. There are required maps: the future land use map, a natural resource map series, historic areas, special transportation areas. The critical thing to remember about comprehensive planning is consistency. The plan must be consistent with state and regional plans. All elements must be consistent with each other. All of the land development regulations that are adopted by the local government must be consistent with the plan. All development orders that specific project approvals must be consistent with the comprehensive plan. During the comprehensive planning process, there are regulatory agencies that have a say. The environmental agencies are the U.S. Army Corps of Engineers that permits dredge and fill wetlands. There's the Department of Environmental Protection, the Florida Fish and Wildlife Conservation Commission. So they look for endangered or threatened species and the habitat of endangered or threatened species that are going to be affected by a comprehensive plan designation. Water management districts, they're concerned with water quality and water supply and the prevention of flooding. Department of Health. Does anybody remember what the Department of Health does with what approval is critical to a development project that you have to get from the Department of Health?
Potable water.
Potable water. Pools also, they regulate pools. Transportation. Transportation agencies will chime in on a comprehensive plan. The U.S. Department of Transportation, not directly, but the U.S. Department of Transportation does require that urban areas have a metropolitan planning organization, an MPO, which is a multi-jurisdictional, multi-government agency. What's the primary thing that an MPO does for the United States Department of Transportation?
Sure.
They prioritize projects for funding. Do you have a question?
Yes. Army Corps of Engineers. How
Yes.
do they get involved?
They have jurisdiction over the waters of the United States. The waters of the United States will sometimes be found in wetlands, not necessarily limited to water that flows, but if the water sometimes flows or ever once flowed, a wetland can be determined to be a water of the United States, and that gives the Army Corps of Engineers jurisdiction to regulate whether that land can be filled.
That's what the federal government used on that pipeline. What was that?
Uniform prioritized projects for.
It's,
I didn't figure out how it worked.
marina development can often require Army Corps of Engineer permitting because you might have to put pilings into waters of the United States that can require permitting by the Army Corps of Engineers. Okay, other flood control agencies, in addition to the Water Management District, could be a local flood control or drainage district that was created by the legislature 100 years ago, and they become very parochial in their view. They're used to being the little king of drainage in some little area. So you can't, even though it's done on a more regional basis now through the Water Management District, the jurisdiction of local drainage districts survives, and you've got to pay them appropriate homage. Schools have something to say about comprehensive planning because they don't control development approval, and development approval can't, and local governments can't control schools, but there's certainly a connection. Every time a housing development is built, there will be children who live there who need to be accommodated in the schools. So where residential is permitted, how dense it will be, what kind of units will be permitted, that all has an impact. And the schools need to know about it so they can plan and have the school capacity ready when the children are there. Plans must be based on professionally accepted data and analysis. This was a change from early zoning was done by legislative fiat without a great deal of study. But now the statute requires that it be studied. Plan amendments. We mostly focused on the expedited adoption process because most plan amendments are done in this way today. There's a proposal phase, which requires a public hearing, transmittal to agencies, an opportunity for agencies to comment, and then there's an adoption, which gets another public hearing. After adoption, the Department of Economic Opportunity or an affected person can request a hearing to challenge the approval of a comprehensive plan amendment. Implementation of comprehensive plans. Remember, land development regulations have to be consistent with the plan, and it's primarily done through zoning. Zoning maps are adopted by ordinance. They designate all of the land within a jurisdiction into a particular zoning district. A zoning code is adopted that establishes what uses are permitted in each district, what uses are prohibited, which of them require conditional or special exception approval, and the dimensional and bulk regulations, parking, loading, we've touched on all this already today. And then what we just did, variances can give you relief from the technical requirements of a zoning regulation, but the criteria are very difficult to satisfy. Site plans are the real rubber, where the rubber meets the road, the approval that is necessary to build a particular project on a particular piece of land. Sometimes there are small bits of development that can be done without the approval of a formal site plan, but in an urbanized area like these 3 counties, it's you can't do much without getting a site plan approval. The typical procedure is an application, staff review, they provide comments, you revise your plans to address the comments, and you resubmit, and then you get a public hearing before some kind of final approving body. An alternative to a traditional zoning and site plan is a plan development. It can be tremendously more flexible. You might persuade the city that the quality of development you offer is so valuable, it's such an improvement that they'll give you some relief from the requirements that would apply in a traditional zoning district. They are, though, project specific, and you must typically provide public benefits to justify relief from strict requirements of traditional zoning. Just today, we already discussed this. Nonconformities, you have to understand what caused the nonconformity, and is it legal or illegal? If you have an illegal nonconformity, you could be subject to a code violation. If there's a casualty, you certainly won't get to rebuild. If you have a legal nonconformity, you have to analyze what degree of casualty is going to trigger the requirements of the new code. Subdivision regulations are technical survey requirements, and then there are also requirements to address the public impact. And they provide a benefit to the property owner. It ensures that your neighborhood is going to be consistent with the neighborhoods around it and of a high quality. And it provides benefit to the purchasers within the subdivision equally, we hope. Okay, that was our review. Now we're going to talk a little bit about the rezoning process. You've all been trying to find, and you have mostly, for the most part, our guys back there, found your project, your case study project that needs to involve a land use plan amendment or a rezoning and a site plan. So let's learn more about how rezoning is different from simply a site plan approval. When do you need to rezone? Now, regulations have criteria, just like we looked at the criteria for a variance. Most zoning codes have a list of criteria that you have to meet in order to be entitled to a rezoning. And those criteria are like this: when the character of the area has changed and the existing zoning no longer serves to advance the comprehensive plan. That's kind of a basic requirement. In practice, you're going to ask for a rezoning when the use or the intensity that you need for your project is not permitted by the existing zoning, and you think you can be successful. Go ahead. Yeah, Fred.
Oh, no, it's great.
Okay, that was okay. What?
We found one.
Oh, okay. We'll stop in time for you to show it. Now, rezoning is historically, under the old model zoning code, rezoning was a legislative decision. A legislative decision is a decision that has general application. It's kind of the highest level of decision making that government officials do. Think Congress in Washington, think the legislature in Tallahassee, but at a local level, it means the city commission or the county commission they decide to change the laws that apply in the jurisdiction. A rezoning is done by ordinance, which is a change to local law, and historically, a rezoning of a tiny little lot or a rezoning of the entire town was treated the same way. They were legislative decisions, and they were not subject to review very readily. It was considered within the discretion of the legislative body. Now, in Florida and elsewhere, rezonings are treated in two different ways. A big rezoning that might, let's say a town here in Broward County wants to create a downtown. It used to be traditional zoning, but they want to create a special zoning district to develop their downtown. So they rezone 40 or 50 acres. Did Oakland Park do it that way? That's legislative. That's a big policy decision that the local elected officials have made about their town. But if somebody wants to rezone their little parcel from a residential 8-unit per acre to a residential 10-unit per acre, does that sound like a really big policy decision that's going to affect the entire town? No. So site-specific rezonings in Florida and in some other areas of the country are not treated the same way as those big policy rezonings. The notice requirements are different, and the standards that apply to the rezoning decision, the legal standards, are different. A site-specific rezoning has to be supported by the comprehensive plan, and there's the hearing is limited to the facts that are introduced in that hearing, and the decision is not given the high degree of they're not given the same degree of discretion. Deference, that's the word I was looking for. So the courts, when they're asked to review a big, broad, town-wide rezoning, that's a legislative decision, and they give a great degree of deference to the decisions of the local elected officials. When they're asked to review a site-specific rezoning that doesn't have those big policy implications, they give the decision less deference, and they treat it more like a trial. And they say, were there facts introduced in the hearing for that specific property that support the decision? The decision has to be supported by substantial competent evidence. So rezonings, they're both types are done by ordinance. In that respect, you'd think they both should be treated the same by the courts, but in reality they are not. Big, broad, owner policy type of rezonings are given great deference by the courts. Those decisions, smaller site-specific rezonings, have to be supported by particular facts that are introduced in evidence at a hearing. So let's talk, so when we're talking about our own projects, do I need a rezoning? You have to understand, what do I want to do with my land? Does the zoning permit it? If not, what can I rezone to that will permit my project? And how likely am I to succeed? Because the politics are always there. Local government, land development, decision-making is always political. And then there's always a legal requirement that there be a consent or a joinder from the current owner. So Noah's going to go out, he's going to put a property under contract, but he's not going to buy it unless he can get it approved for the project he wants. So as part of his purchase and sale contract, the owner agrees to sign applications as may be necessary for him to see if he can get his project approvals. And then after he gets the project approvals, then he's going to close, right? Okay. So even if the process is being administered by a buyer who does not own the property owner still has to agree and sign on to the application. Because once rezoning is done, it's done. And if the sale doesn't go through, the zoning has changed. So here's the typical criteria for rezoning. Each of them is a little different, so you have to find in the code what the criteria are. The proposed zoning district must be consistent with the comprehensive plan. There must have been substantial changes in the character of development or in or near the area under consideration to support the rezoning. So an increasing intensity of urbanization would support a rezoning to a more intense zoning district. Yeah.
Going back to your other comment, what happens if, the loan does, well, the purchase doesn't go through and the project is now, well, the land is now rezoned and the existing owner is still there with the previous, so what happens?
The owner could go through a rezoning again to ask that it be restored to the old zoning.
Mm-hmm.
There could be a post-closing or termination obligation on the part of the buyer to undo it, if it's that important. I'm trying to think of a good example of this. I was talking about mobile homes. So a colleague of mine was advising a lender on a mobile home park in a city here in Broward County. A buyer of the property had come in and changed the land use and the zoning to redevelop the mobile home park as, you know, I think it was probably just a multifamily, and then didn't close. This was probably 2007, 2008, we know what was happening then. Okay, so they never closed. Then the existing mobile home park continued to operate, but it was no longer permitted by the land use and zoning. And the lender, and the city was being very, very aggressive. They were starting to withhold the building permits necessary to take out an old mobile home and put in a new one on the same pad. Because they said, I can't issue a building permit that is inconsistent with the comprehensive plan. And they were kind of right, but they got sued. And they reached a settlement to allow the mobile home park to continue operating as a non-conforming use. But they did not go back and undo the land use change. But that was the situation exactly that you described. So the seller of land who consents to a rezoning needs to evaluate, where do I want to be? What situation do I want to exist if this sale doesn't close? Maybe it's still a beneficial rezoning for them, and they believe that it'll increase the value of the property for the next buyer. So,
As a seller, I would demand a fee from the buyer. It's like an option fee, that's something.
yeah, I mean, that makes sense. And if you decided to revert to rezone it yourself or something like that, it would fund
Right.
that, yeah.
But is that an automatic guarantee that the city will revert? Because
No.
like you were saying, they were trying to get rid of the mobile home parks.
No, there's no guarantee. A site-specific rezoning, if both the old zoning and the new zoning were consistent with the comprehensive plan, there's no guarantee you're going to get it reverted. There is not. I mean, and there are very few uses in an area like South Florida today that have that sort of treatment as mobile home parks, because, I mean, cities sometimes hate them, sometimes they don't hate them because it's really the only form of affordable housing that they have in their jurisdiction, but a lot of cities really hate mobile home parks, so it can be a challenge. All right, so more of these criteria. So there must have been changes that support the rezoning of the property. The character of the area has to be suitable for the uses permitted in the new zoning district. It has to remain compatible with the surrounding districts and uses. The proposed district will not create an isolated use or constitute a special privilege. And the proposed district will not have an adverse effect on property values. These are just an example of this rezoning criteria that are found in many zoning codes. All of you now, with your projects, are going to be reviewing those criteria for your case studies. So somewhere in that staff report, the staff is going to have to pull those criteria out and write a narrative about how this proposed rezoning satisfies those criteria. which is why I wanted a rezoning in your case study, because it's much more judgmental than a site plan. A site plan, it's, you know, it's much more specific, it's much more fact-based, but the rezoning criteria require the application of judgment. And I want you to get a sense of what it takes to get a city planner to agree that that rezoning is appropriate.
I have a question. Can we, and I know our time's limited on it, if I put down a deposit on a parcel, the due diligence period, and then we start applying, can we do that as a project?
For this class,
Because I'm looking at a couple pieces right now, which would need to be,
the timing,
it's gonna be.
it could take you the rest of the time we have in this class to get a surveyor on board, you know what I'm saying?
Yeah, never mind.
I'm just thinking, I don't think we have time to go
Alright.
through a project with you. So what are you gonna, typically for a commercial deal, you could have 30, 45, 60 days
I was
due
gonna do a
diligence.
60-day due diligence.
And then maybe you go hard, but you still don't have to close until you get your site plan approval, right? That's typical for a commercial deal in South Florida. Nobody closes until they've got the final approval. I would say nobody. It's not true nobody, but hardly ever. Okay. So the procedure for rezoning begins with an application. You have to look, just like we looked at the site plan application for Fort Lauderdale, you have to look at what the requirements are for the application. Sometimes they just want a legal description. Sometimes they want a conceptual site plan with aerials and photographs and a lot more information. It goes through review by staff. Some cities send it around to all the same agencies as would review a site plan, and some of them are more limited, and only the planners look at a rezoning. There's always public notice required. For a site plan, it may be a general notice, like an ad in the paper, or a posting of a sign, but for rezoning, they almost always require you to give specific notice by mail to property owners within some number of feet, 300 feet, 500 feet of the boundary of your property.
Is it always called the DRC or no?
No, it's called like, when you're looking at the university, I mean at Miami, the city of Miami, what did they call their stack, CRC?
Yeah, that was for the special warrant permit, but I actually found their website in the city commission, which is kind of neat, because it's got the minutes, and then it's got the video, and you can click on the video, it's got a table of contents, and you can click on the agenda item, and it'll take you to that point in the video where they're
Okay.
discussing.
Good, but what was the CRC, what did the CRC stand for?
I have it here.
Remember,
The
community-
CRC is, see right now. It stands for Coordinated Review Committee.
Okay, that sounds a lot like DRC to me. So they can
Okay.
call them different things. In Hollywood, they call it Technical Advisory Committee.
But that's only for waivers, warrants, and exceptions, not for zoning changes. It doesn't go through
Okay.
CRC.
But it sounds like it's like a committee of staff members. And really, when I say DRC, by whatever name, I mean representatives of city agencies who are employees of the city, or maybe consultants, who review a project for a specific discipline. So an engineer reviews it for engineering, a landscape person reviews it for landscaping, you get what I mean. Okay. So rezonings usually are reviewed by an advisory board. It's usually at a public hearing. That's where neighborhood opposition can first appear, unless you had some kind of outreach to the neighborhood before the rezoning. You want to get out of the advisory board meeting with a recommendation of approval, but sometimes you just want to get out and move on. And especially if you believe that you can persuade the city commissioners in spite of the recommendation of denial from the planning and zoning board, then you just want your decision and you take it out the door, you move on to the city commission. It's an advisory board. Sometimes a negative advisory board is gonna kill you though. You have to know the politics.
I was looking in Fort Lauderdale and said review advisory board recommended 8-0, right? Is there any case in which the advisory board would recommend it 8-0 and the city would say no?
I'm sure there is. I mean, I can't think of one.
Or what would be a reason if everybody's for it that they,
So, you know, I'm trying to think of Bahia-Mar, but I don't know if they needed a rezoning. I don't think they did.
there was, I know Lauderdale Yacht Club got rezoned.
Did it, was it approved, what is recommended for approval by the planning and zoning board, but, I'm trying to think of an example.
I was just curious as to whether or not a city would ever overstep and say no, not at all.
I mean, you know, I don't know if it's overstepping, but from a city commissioner's point of view, they're saying, I'm elected to bring my judgment to bear and to listen to my constituents. And, you know, I don't know why the planning and zoning board approved it, but I'm the ultimate decision maker, and I don't think this is in the interest of my community. Now, there have to be facts. So it could be that there was a complaint about traffic, and there was a traffic study, and the planning and zoning board became persuaded that the rezoning was not gonna have that big of an impact on traffic. But the neighborhood comes out more strongly at the city commission meeting, and they bring their own traffic expert who puts information, actual data into the record to support the degree of damage to the traffic that will result from this rezoning. So the facts changed. Maybe before the planning and zoning board, the facts about the impact were not that well developed, but they got to the city commission, the opposition brought more experts, brought more information that put facts in the record that supported the city commission denial. It could happen. It could happen. I'm trying to think of an example. I think that in Pompano, I've gotten, for example, I think I've gotten recommendations of denial from an advisory board and then been approved by the city commission. Again, the city commission, they might take the economic benefits into consideration and weigh that more heavily than the advisory board would, because they know that they need the economic development that's associated with the project. So there are reasons that the two things can come out differently.
Like the parking garage,
Like what?
the parking garage
What parking garage?
along the beach, because there was no parking in Pompano Beach, so they developed this, I think it's a 5-story parking garage now, and it's bringing people to actually go to the beach.
Yeah. I mean, it could be that the neighbors hate it, and because the neighbors hate it, the planning and zoning board recommended denial, but the city commission had a bigger perspective. And they realized, yeah, it's gonna be kind of rough on the neighborhood for a while, but it will bring business to the beach and be better for the city overall. See, that's how it could happen. So in Florida, cities require 2 hearings to adopt ordinances. The county commission only requires 1. The county commission is the zoning authority only for the unincorporated area. In Broward County, there's not much of that left. In Palm Beach County, there's a lot of land that is still in the unincorporated area. So the county commission does the zoning decisions. But cities, 2 hearings, county, 1 hearing. So if a rezoning is denied, and this is what I was describing to you earlier, the site-specific rezoning, small decision, small impact, it's called quasi-judicial. The hearing before the city commission on a site-specific rezoning, it almost becomes like a miniature trial. So witnesses will be sworn, evidence must be relevant, there must be substantial competent evidence on the record to support the decision. And this is the criteria that was the most disruptive to land use practice when this first came into being. Ex parte communications are either prohibited or they must be disclosed. So what I mean by ex parte. So if I'm a developer and I have a rezoning pending before the city commission, or before the city, and I know I'm gonna end up in one of these kind of hearings, I'm either prohibited from talking to the city commissioners outside of the hearing about the issue, or if I do it, it has to be disclosed on the record. Cities have somewhat different rules on it. So if you go to a planning and zoning board meeting or a city commission meeting in Fort Lauderdale, for example, on a rezoning, the city attorney will ask for disclosures. And they'll go down the dais and they'll say, I spoke to the developer's attorney. I spoke to the developer's attorney. I did a site visit. I spoke to the developer's attorney and I did a site visit. So they're disclosing on the public record what information they learned outside of the hearing. In theory, the disclosure is supposed to give the applicant the ability to counteract. So, but in reality, those disclosures don't tell you much about the content of the discussion.
What do you mean, it's supposed to give them something to counteract?
So if it's a hotly contested issue, and one of the planning and zoning board members said, I talked to the developer's attorney, you know, he called and I had a conversation with him about the project. In theory, the opposition could cross-examine about that.
Oh,
Really,
they could
when he called, what did you talk about? What were your concerns? How did he respond to them? Did he make you any promises about it? You can, now it doesn't happen very often, but in reality, the two opposing sides on the decision can cross-examine the witnesses on the other side to try to uncover, you know, some misinformation. Oh, he told you that it's only going to be 15 stories, but look at the application. It's actually 18 stories.
So, are
maybe
you
so.
allowed to make essentially,
Donation.
yeah, are you allowed to make donations to the city? Is that legal? For them to, maybe to incentivize, or can they request financial contributions towards, for example, infrastructure, and you give them that money?
Okay,
Use the Trump.
complicated. Any development, usually there is a provision of code that allows the city to require you to mitigate the impact of the development. Okay, so right-of-way dedication, they want you to widen a road, or at least give them the land to widen the road, because your development's going to put more traffic on the road. You remember those constitutional takings cases that we reviewed? The exaction must bear a relationship to the impact, and it must be proportional. So the code allows them to say, give us right-of-way, give us land for a park, if it bears a reasonable relationship to the impact of the development, and what's required is in proportion. So that they can do. What often happens is a developer will proffer or will offer to voluntarily contribute or assist with something to mitigate the impact of the development. That's for it to be contemplated to be, I would say for it to be legal, because I don't really know that that's the case, but generally contributions or exactions should be related to the impact of the development.
So you can't, if you need to put a sidewalk, you can't give them $20 million. You build the sidewalk.
I'm not really opining on anything being legal or illegal.
All right.
I'm just saying that even a lot of developers, and maybe it's because they really care about the community, and maybe it's because they think that it's going to help their cause, they say, you know, I'm required to give you money for park impact fees, and I'm required to dedicate land for widened sidewalks. But in addition to that, because I care about the community, I'm going to create a public plaza, or I'm going to contribute to your affordable housing fund, or
Your park beautification fund.
right, something like that. Many, many developers proffer more than is required of them. It happens. It happens.
Okay.
Okay. And we're gonna review, the idea of contract zoning versus development agreements, and try to find the fine line between contract zoning, which is illegal, and development agreements, which are legal. All right, so the appeal of a rezoning. You have to go back into the record of what occurred at the hearing and make the argument that the decision was not supported by substantial competent evidence. So clearly you need lawyers for this. It's based on the record of the hearing. Remember when I talked about the olden days when all rezonings were considered legislative and given deference by the courts before this site-specific rezoning was treated differently? In those days, the hearing before court, you started over. It wasn't based on the facts that were introduced in the hearing at the city commission meeting. You got to start over in front of the court and say, you know, no matter what we said back then, we've got a really good reason to support the decision here. It was called a de novo, or a new hearing. When I was a law student, I assisted a city attorney with one of those trials where a site-specific land use decision was appealed, and it was a de novo hearing. We dragged in experts that never appeared at the hearing below to support the decision. It was a brand new hearing. But now, site-specific rezonings, the appeal must be based on the record created at the hearing. You don't get to start over. So in this broad-based rezoning initiated by the city to implement a new plan or policy, those are not quasi-judicial, those are considered legislative. They're given deference, and the appeal is de novo. De novo. For all rezonings, there's typically a prohibition on applying for the same thing again after a denial for some period of time. We just did planned development districts today. See, I knew I had more material on planned development districts, and this was the type. Okay, we're not going to get into this. We're going to stop. Questions? Do you guys have a bean on a site now you want me to look at?
I was a question about the midterm. In terms of what about it from the reading, is it just chapters 1, 2, 3, 4, and 10, or will it be?
Everything through the completion of next week. So, but the assignments were done in two-day assignments. Let me look at the
Yeah.
So it's, a lot of it's gonna be from the land use book.
I don't know. I haven't read it yet. Let me look at the. Oh, no, it's good now.
Yeah, I'm just saying.
We should do it from the slides.
Thank you for your.
Yeah, I figured you really care.
Want to give you constructive feedback?
So the reading that could theoretically be on there is the Mandelker, chapters 1 and 2, the nutshell 1, 2, 3, 4, and 10. Mandelker 1, 2, and 3. So all of the reading assignments through the September 17th class.
And nutshell,
Nutshell 1, 2, 3, 4, and 10.
and Mandel 1 through 3.
1 through 3, which is all that I gave you at Mandelker. It's hard to read, sorry. Wait, don't anybody leave. I didn't have to sign in. It's the end of the month. No, they're like really neurotic about this.
Yeah, we got any grandkids.
Nope, it's 3.
You know the grandkids are coming.
Oh, yeah.
Yeah, they coming. Our children are gonna stand up.
That's your pen, right?
Okay, I did forget that.
This is what it
Thank you, bye-bye.
without using different numbers that are different.
This guy.
Chief. Later, man. Goodbye, man. The cool thing about this website is City of Miami, and then if you do a keyword search for rezoning,
Yeah.
Alright, we're gonna-
Really?
You just signed, right?
Oh, I'll hit the road and drive.
Oh, you drove.
Oh,
Okay,
God.
they
Here on
say,
the City of
Trying
Miami
to test it
website,
out.
was it like
September
4?
24th,
Yeah, almost.
Okay, have a good drive.
Thank you.
The 24th right here, rezoning, so. A bit of a rezoning.
Amending the zoning hours. Amending the zoning classification. Okay, so there's the rezoning.
And then here's where the motion passed.
Okay, and you know, there was a site plan amendment too?
That's the part.
Let me see if our analysis graphs affect supporting document.
Okay, we'll see you
All right,
next
guys.
week.
All right.
We'll email you our information.
Okay.
Thank you.
Well, it's still loading. It's a big file. Should be something. So so that works as long as it has a site plan?
Yep. And as long as there's a conceptual site plan,
Yeah.
the rezoning, maybe it's not a formal building site plan, but if there's a conceptual site plan
I'll
with,
I'll look at it
okay.
at
And
home.
then somebody
If it
send
doesn't
me
have a
an
site
email.
plan, I will definitely pick one out that has a site plan.
Okay,
I like, I mean, I don't know if the city of Fort Lauderdale has this kind of feature with the thing and then you can come here and actually select it and, PC9, and then you can actually
you
view
know,
the,
Margate, I mean, strangely, there are other cities in Broward that do, I don't remember if.
I know when you're down at the actual office, they show it, but I haven't seen it on the.
Yeah, I don't remember seeing it on Fort Lauderdale either.
Oh, here. City of Fort
But again,
Lauderdale.
the video is only, you know, it's not necessary for the case study.
it gives you some insight into the process
Mhm.
as part of this,
It
right?
does. It does, so it
Part of this whole
makes
thing.
for a more interesting analysis.
I have another one that maybe could work if that one doesn't. Which are warehouses that were switched from B3 to B2. Where would I not sit on this thing? So would Broward.org have the site plan?
No,
No.
not unless it's in unincorporated, well, even then, no.
Mayor Russell,
Yes.
Commissioner, go ahead.
So I just have to go to the city or contact the city for the site plan?
You should be able to find it through the minutes.
I don't have a parking pass here, I just can't manage to come in and get one, so I have to get my husband to pick me up.
Oh, look at this, there's the agenda, Harbor Park warehouses.
rezoning them?
It says rezone from residential low-rise multifamily to high density to parks, recreation, and open spaces.
But did they ever propose development? I mean, was it just to conform the existing uses to a more suitable zoning?
You know, I don't know, this is really not that descriptive.
No. Okay, let me think.
Here's the development review right here. Let's see what this looks like.
I'm trying to think of some of my own examples.
Here's the DRC meeting. Land use case planner, has a case number. That won't really help, will it?
Oh, there's so many documents on here, I'll find a second.
Oh, look at this.
Well, and honestly, I'm trying to think of where I've done work where I know that there was a rezoning and then a contemporaneously approved site plan. I wonder if the Art Square had a rezoning. Hallandale. It's part of a city rezoning. Do you want to do something in Miami?
No,
Because
I'm sure. Doesn't have to be there.
Here's the DRC report. Case comments. General comments. Variation, oh, H. Meeting details. Legislation details.
Oh, here we go.
Here's the
No,
minutes.
This is a survey.
is that the Miami one? Is that
Yeah.
what you're looking at?
Yeah, well, he's looking at the other one, I was looking at this.
We're just trying to find one.
Yeah. We'll find one.
Ordinance, quasi-judicial, second reading of ordinance, rezoning, sponsor, attachment, here's the agenda, the exhibit, location map, applicant's narrative, staff report, planning zoning approved minutes, ordinance. This looks like it has a lot.
Yeah, but you don't know if it had a site plan. Was that the yacht club?
Pass. No, this is the warehouse is just right near the Port Everglades, where they have the.
So read a staff report and see if.
Right here. Next to these.
So, I mean, where?
See, right here.
Okay. So it would require, are those existing buildings or is that
Yes.
vacant land?
No, those are existing buildings.
Well, why don't you read a little bit of the staff report and understand why they want to rezone it? Because they're not gonna
Staff
do it for no
report
reason.
Right here. Mixed use development.
So the applicant is requesting to rezone the subject property from blah
To
blah
general
to
business.
blah blah associated with the development of a new mixed use.
project.
Okay, so the new mixed use project would also require a site plan.
690 residential flex units available.
Yeah,
So what's the project called, or what's the applicant?
Is Harbor Park Warehouses LLC.
So, I mean, you can wait and call them and say, can you help me find a site plan associated with this rezoning? What was the date of the rezoning?
2013.
Oh, okay. DRC agendas from that period and see if you can find,
Well, they have the DRC agenda, right?
but that's just for the rezoning. You know what I'm saying? It would be a separate application for the site plan. And if none of the reports say this is related to site plan application number blah, 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 then you have to go hunting for the site plan. Sometimes the staff report will identify the related applications. I have to go out.
Okay,
My husband's gonna pick me up.
all right. We'll find something, we'll email you,
Okay,
we'll find a site plan.
all right. And you use my law firm email,
Okay.
if you will.
Let them,